I'm so excited. Today we're going to talk about civil rights and civil liberties, near and dear to my heart. This is important. There's a distinction between a civil liberty and a civil right. A civil liberty is something we've always had, and it's a thing that we're going to protect against the government. So we're going to restrict government from taking that away from us. Sometimes it's called a negative freedom because they prohibit governments from taking them away from us. Civil rights, on the other hand, are something really interesting. These are called positive freedoms because the government must act to protect them. They're granted from the government to us. They're rights of individuals to be treated equally by governments. In other words, the difference between a liberty is something that we already had and a right, which is we're granted by government. We're going to talk about that. Civil liberties we always had. Civil rights the government gives us. Now, there are lots of stories inside your book that talk about equal rights and all these other things. There's lots of cases, marriage equality, we talk about race equality. One of the things that's really, really key is that not all of these rights are very clear. Some of them are explicitly given to us in the Bill of Rights, but other ones were sort of constructed over time. And one of them is the right to privacy. For example, the right to privacy is not described in the Constitution. It was created by the Supreme Court, surrounding a lot of other issues, but some of it is like physical intimacy and sex. So, for example, in Griswold versus Connecticut, there were questions about whether or not somebody could use contraceptives to prevent pregnancy within marriage. And then later in Lawrence versus Texas, there were questions about whether or not homosexual interactions would be treated equally as heterosexual interactions. And then questions about right to abortion. But the right to privacy wasn't granted to us through an act of Congress. It was given to us as a set of penumbra of considerations. They call this an umbrella look-like thing of different rulings from courts about what our restrictions on, what government restrictions there should be on privacy. Now, privacy doesn't have to deal with sex. It could deal with what we do on the internet. It could deal with what we say. But there's a constructed right to privacy that doesn't really exist. So, interestingly, when we look at the source of all these civil rights and civil liberties, we can look at the Constitution and the Bill of Rights. The original Constitution did not include a Bill of Rights. Remember, we talked about that as a concession from the Federalists to the Anti-Federalists to protect those Anti-Federalists and to give them a clear definition of what the federal government could do and could not do. So, those are the first 10 amendments to the Constitution, and each of those restricted government action. They prevented government from intruding on an individual's right. In other words, these were civil liberties. Now, these are interesting. The Constitution and the Bill of Rights, we can look at all those over here on the First Amendment, the Second Amendment, Third, all the way through the 10th. We know most of these. The First Amendment's about speech, religion, press, assembly, right to petition the government. Second Amendment about firearms. Third Amendment, quartering troops in homes. Fourth Amendment, unreasonable search and seizure, warrants. The Fifth Amendment, non-self-incrimination, the grand jury and indictment, protection against double jeopardy, right to due process, all sorts of things happen. We can look at all these things now. All of these rights are restrictions against the federal government. So in other words, all of those in the Bill of Rights restrict the federal government from invading on federal citizens. Now, we talked about federalism. Federalism is this, that the citizens are both citizens of the federal government and the state in which they live. So the Second Amendment doesn't really apply to the states. It only applies to the federal government. So what happened was we had to figure this out. What's a right? What's a liberty? When does it apply? And who does it apply to? So typically we think about these Bill of Rights applying only to the federal government. But what happened was the passage of the 14th Amendment and the extension of the Due Process Clause applies the Bill of Rights to the states. So this process is called selective incorporation. And what happens is that a court case will come and question the authority of the state to impose on a right or liberty of an individual. And the question is whether or not the 14th Amendment and this due process cover the rights of a federal citizen living inside of a state. Now, so selective incorporation happens as a little bit over time, and we'll talk about some of these. For example, the First Amendment does apply to restrictions on the states. So the state can't has to have some reasonable restrictions on how it can restrict religious expression or freedom of speech. The Second Amendment, which is interestingly, this is one of the most recent civil liberties to be civil rights to be selectively incorporated. So up until 2010, the right to keep and bear arms was not a right that was given to all citizens of the states. So states were passing all sorts of firearms laws that were restricting the rights of citizens inside their states. When McDonald versus Chicago came, it became clear that the states, that there would be a logical right to keep and bear arms that could not be impeded upon by the states. Now, we knew that it couldn't be impeded upon by the federal government, but until 2010, we didn't know we didn't know how that right would apply to the states. So as we look at over time, the selective incorporation of these federal Bill of Rights happens to the states. It's not a clear process, and some of them may or may not ever be incorporated, such as for example, the right to indictment by a jury case involving a serious crime is not incorporated in the Fifth Amendment. It's not really clear. There's not been a case that's made that possible. A right to a trial by jury in civil cases down here, the Seventh Amendment's not incorporated. The Eighth Amendment, there's some disagreement about whether or not excessive bails and fines can be levied at the state level, but definitely not at the federal level. So we're still waiting on how all these happen. Now, I'm going to go very, very quickly through all of these, but you should look at it in the book to try and identify how these happen. The right to free religious exercise is an interesting right because it requires the government to tolerate some religious expression, but it also prevents the government from endorsing a specific religion. So we have this wall that separates between religious endorsement, so the government can't endorse a religious preference, but it also can't discriminate based on a religious preference. So we should look through some of these things. There should be some restrictions on free exercise, maybe, but there's this ongoing thing about whether or not some citizens can, in their practice of religious experience, impose on the rights of somebody else, or whether or not the government can limit those things. For example, can a religious individual prevent a doctor with whom they disagree on their practice, prevent them from saving the life of a loved one or a child? So what sorts of, what is the boundary between religious expression and saving the life of another individual? There's all sorts of questions. Questions about freedom of speech, first freedom. Right? There's some really cool, interesting ones which you should look at, but there are some limits on when we can express ourselves. So, for example, there's a limit between calls to action, like inducing a riot. That has to be limited. Yelling fire in a theater. You can't just sort of say whatever you want. Whenever you want. There should be some reasonable limits on expression, but they shouldn't necessarily be political. Now there's some questions about what rights and restrictions are there for free speech in terms of libel, expression in written form, or slander, what you can say which is true or not true. Hate speech that has no purpose is banned. And there should be some limits on obscenity and pornography, which is interesting because we say, what is pornography? The community standards change over time, and the courts have essentially said, well, we can limit pornography in terms of whether or not it's about a child, or if it's blatantly outright pornographic or obscene without any artistic purpose. And we say, well, what that standard look like? And we say, well, I don't actually know, but I'll see. When I see it, I'll tell you if it's pornographic. So some of these rights and liberties are constantly in flux. Oh man, so many good things about whether or not we can peaceably assemble and where we should there be limits on that. So, for example, should we allow individuals to assemble and protest? To what limit? Can they just show up in the streets and protest, or should the government be able to impose a place in which they can protest? Should the government have some restrictions because it's going to use government resources to ensure their own protection? So if we have a KKK rally, should we grant them a permit to rally in the streets? Well, it's going to block the streets. Well, should we put them on one corner? Well, does that allow them to express themselves properly? So we have these balancing competing interests where the government has an interest and the citizens have an interest, and we try to figure out what the right is and how that works. So Second Amendment, we've talked about guns and firearms. It's kind of an interesting thing. It's been selectively incorporated. Some of the more interesting ones are like these are procedural limits. So can the government violate a procedure in order to get somebody convicted? Well, no, we have to protect them. And so there's all these ones you should read in the book, but these procedural liabilities or these procedural liberties are interesting and freedoms. So we have ways in which we are guaranteed individuals the right that we're not going to violate some standard in order to get evidence from them. So, for example, probable cause or having a warrant. A warrant is a check on government's power because it requires the executive branch to petition the judicial branch for permission to go into someone's home to make sure that they're not violating some procedure that would deprive an individual of their privacy. And if they do violate that, Mapp versus Ohio, for example, says if you don't give these people procedural rights or liberties, then we can exclude all that evidence that you have used in your case. So it's as if that evidence doesn't exist. There's all sorts of these amazing protections, like you can't be prosecuted for the same twice. You can't be convicted of the same crime twice. You have to be indicted by a grand jury, and you can't be forced to incriminate yourself. Speedy trial. You know, if you're caught and you're arrested for something, you can't just sit there in jail forever. You have to be tried by an impartial jury, a right to an attorney. All these things are procedural things to check government's power. They can't impose excessive bail because of the Eighth Amendment. They can't punish you cruelly, unusually. There are questions about whether or not a capital punishment or bodily punishment impose a cruel or unusual punishment on your individual. Can we require that if you're convicted of a crime that you serve a minimum sentence? Can we punish people who have limited cognitive abilities? All of these questions are still being worked out because they're guaranteed in the Constitution, but how we implement them is actually a big question. The 10th Amendment is really interesting. It essentially reserves all the rights to the state that aren't specifically given to the federal government. This is the basis of states' rights. Now, after the Civil War, we tried to figure out how different groups of individuals were protected or not protected based on rights and liberties. Reading through that, the 13th Amendment prohibited slavery. It said you can't do this thing to this group of people. The 14th Amendment, we've already talked about, established this idea about selective incorporation, but it essentially says if you're born in the United States, then you should have all the equal protection of all the citizens, and you become a citizen. And essentially it says all citizens should be treated equally. The 15th Amendment established voting rights. States tried to fight against that, to promote segregation, and we've used the 14th Amendment to ensure equal treatment, or to try and ensure equal treatment across all the states. For example, we had Plessy versus Ferguson, Brown versus Education, which dealt with, well, read them in the book, but how we deal with equality. Could you have some separation but equal? And essentially, over time, they said, no, you can't. You have to treat them equally, but not just treat them equally, but they have to be in the same space. Now, this is interesting. The establishment of Brown versus Education and desegregation started this process by which we reintegrated groups of people who had historically been segregated. Now, why is this important? Because essentially every other protected group has followed the same pattern that African Americans had as they asked for civil rights to be extended to them, or in other words, protections from government to ensure equal treatment. Now, Civil Rights Act, Voting Rights Act, all of these things were essentially accommodations or government's attempts to ensure that the equality or that the liberties that were guaranteed to all citizens were implemented equally. So we talked about civil liberties, these rights that we had, like to free speech or to firearms or to whatever those things were. They are there, and we're preventing government from imposing on them. Now, civil rights are the opposite. We say, well, if everyone's to be equal, how does government step in to ensure that everyone can be treated equally? And so we set up protections to keep them that way. You should look through here the chapter when we talk about segregation. Segregation happens by law, which is de jure, or de facto because they cluster and group in other areas. So There are questions about whether or not de facto segregation should be treated the same way as de jure segregation, where we know de jure segregation, separation of individuals based on law, is absolutely unconstitutional. Affirmative action is this policy that attempts to deal with that. And I guess we'll end up